Welcome everyone to Chapter 1 of Dispute Resolution. Mostly, this area of law is challenging, you need to memorize dates, process, and load of things. But my tip and trick for all of you is just wave your understanding of dispute resolution around some hypothetical case, some fiction, and all. Once I was teaching, I used to do things and associate them with people around me. So if someone was going through a civil procedure case or they were just going in county court and they were following processes and all, so at that point it was easy for me to understand and memorize different dates and all about dispute resolution. So without further delay, we will start with dispute resolution in England and Wales. This is where our SQE journey is it becomes a bit bumpy, but it is a vital topic because the civil procedure rules underpin almost everything you will face in civil litigation questions. And it is an area that makes hell of money for its readers and people who understand it and practice it. So now think of the CPR as the rule book of a very organized football match. Except instead of goals, we are aiming for justice at proportionate cost. In this session, I will discuss the civil procedure rules, the court's case management powers, the role of litigant in person, and the structure of civil courts. So grab a coffee or chocolate and let's get started, because unlike real litigation, this will not cost you £300 an hour. Rather, you will charge it from people. So the civil procedure rules, or CPR, form the backbone of civil litigation in England and Wales. Now, the overriding objective in the North Star of the CPR, the court must deal with cases justly and proportionate cost. That means no dragging things out, no drowning your opponent in paperwork, and no turning up with a 200-page skeleton argument for a small claim. But you need to give everything proportionate, and small claim about broken toaster cannot go very complex. So we also talk about parties being on equal footing. This means the rich company and the average individual should both have a fair chance, at least in procedure, if not in budget. And remember, proportionate handling. A small consumer dispute is not managed like a multi-million-pound corporate case. If you remember that principle, you are already ahead of your SQE1 multiple choice questions and you will be tested in it. So now, two pillars hold up the overriding objectives. And if you forget these, the examiner will be waiting for you. So be careful. First, alternative dispute resolution, or ADR. The court loves it. Mediation, negotiation, any method that avoids a full trial. It is cheaper, quicker, and less emotionally draining. In fact, if you refuse to try ADR without a good reason, the court might hit you with a cost order. So careful. Second is compliance. The CPR is not a suggestion, it is mandatory. If the judge says exchange witness statements by Friday, do not risk Friday-ish. Will do. So at that point, you should meet the deadline given by the court. The court enforces its orders seriously. So in exam, when you see a question about a party missing a deadline or ignoring directions, remember, non-compliance means trouble. So let's take a quick trip West Wales and try to understand where the law speaks two languages. Under the Welsh Language Act 1993, the Welsh and English languages have equal status in legal proceeding. That means anyone can speak Welsh in court if they chose, or they choose to do it, So you can't stop people from speaking Welsh language. The CPR can make sure this right is respected. So court provides Welsh language facilities, interpreter, and even full hearing in Welsh if everyone agrees. And here's the key SQE1 takeaway. If someone ignores these rights, for example, a solicitor fails to notify the court that their client wishes to use Welsh, there could be cost consequences and all. So yeah, whenever I talk about Wales, I always talk about North Wales. So that's because I like North Wales a bit more. Sorry for that if you live in South Wales. So the next is on the mighty case management powers of the court. There are judges become part referee, part project manager. So they try to just look at the directions to make things proportionate between the parties, or make things at par between the parties. So under CPR 3.1, so CPR once again is Civil Procedure Rules, the court can extend or shorten deadlines, adjourn or bring forward hearings, and even hold them online. Thank you, modern technology. This can consolidate cases, split them up, or order parties to file cost budget. Essentially, the court can do whatever it needs to make the case run efficiently and fairly. Even steps not specifically mentioned in the CPR. For your SQE1 preps, remember that these powers exist to further the overriding objectives that we have already talked. Whenever you see procedural question, ask yourself, does the court's decision make the process fair, proportionate, and cost effective? If yes, you are thinking like a judge. Wish you all the best that you become judge one day. Right, now let's talk about litigants in person, LIPs. These are brave souls who represent themselves, sometimes poor souls as well, without lawyers, like me. They can't afford lawyers, so they want to litigate in person. Sometimes it works well, other time it is a bit like doing your own dental work. Don't do it. Technically possible but rarely advisable. The courts give LIPs some leeway because they are not legally trained, and this is important, they still have to follow the CPR. They need to understand dispute resolution, or they need to watch my these discussions. The judge will not rewrite the rules for them, of course. They will be following civil procedure rules. As for lawyers dealing with litigant in persons, the SRA principle requires fairness, not taking unfair advantage. Now, zooming out, we have the civil court hierarchy at the top. That is Supreme Court sitting at the top, then the Court of Appeal Civil Division, because we are talking about civil cases, and it is followed by this High Court with its Chancery King's Bench and Family Division, and finally the County Court around us, where most everyday disputes starts, like contractor or small claims and all. In your exam, be sure you can match the right claim with the right court. The wrong forum can be costly in real life and fatal in exam, so be careful. So, now time for SQE1 exam strategy. This slide is gold dust. Careful. When you face procedural question, look for references to proportionality, fairness, and cost. That usually signals the overriding objective. Always think, could the court use its case management power to fix the problem? Yes or no? ADR is not optional. That's what you need to keep in mind. It's not an advice, it is failure to consider. It can be punished. Not punished in a way like, that you are thinking maybe compensation or cost will be paid by the party at fault. Know the court hierarchy and where each case belongs. So if the option is that should it start from the Supreme Court, be careful, cautious about it. Remember that every litigant in person are subject to rules. They need to follow CPR, but they get certain flexibility in court. Common pitfall: easy, confusing criminal with civil procedure, ignoring compliance issues, or thinking proportionality means do whatever feels right. It does not. It means balance, and that balance is what the CPR is all about. So revise smart, read each question carefully, and remember in the SQE1, as in life, deadlines are not optional. Thank you very much for being with us, and you will find our notes and question bank to prepare effectively for your SQE1. Take care. Ta-da.